Welcome to Hiraeth, a home for the left in Wales.
Joining me in Rich tonight is Jeremy Miles, MS. He's a member of the Senedd for Hiraeth. He's also the Welsh Government Brexit Minister and Counsel General. Hello, Jeremy.
Hi, Matthew. How are you?
I'm very well. Thank you very much for coming on. We wanted to start today's show by just talking very briefly about what your concerns have been with the UK government's Internal Market Bill. Would you be able to summarise that for us?
Yes. Well, fundamentally, it's as a government, we support the idea and principle of an internal market. It's good actually for Welsh consumers and Welsh businesses, and obviously helps with the UK economy functioning overall. So we are absolutely supportive of making that work. Our problem with the bill is that it's not remotely needed in order to deliver the internal market. And, it seeks to do that at the expense of the devolution settlements, basically. So, it drives a coach and horses, really, through the ability of the Senedd and Welsh ministers to be able to maintain the high standards that Welsh consumers have rightly, obviously, valued. And it is absolutely the case that the lowest standards in any part of the UK in future will be baked into the economy. And obviously, we have a government in Westminster which is keen on deregulation. So the risk is obvious. There's a constitutional argument, which I myself am completely persuaded by. But even if people aren't persuaded by that, this will affect people in terms of their weekly shop, their interest in the environment, interest in animal welfare, all sorts of issues, really. And it's been done in a way which has involved no consultation with the devolved governments, and we just think that's wrong.
What are some of the alternative proposals that you've made to the bill, and how would they address the problems that you find with the bill as it stands?
Well, first thing to say, I guess, is, I met with UK government ministers yesterday, actually, to make the case, because I think it's important to take any opportunity to do that, really. And obviously, some parts of the bill are, less problematic, obviously, than others. But the sorts of things that we have been saying we would need the bill to be changed in order for us to reflect the kind of proposals we've put forward are as follows, I guess. Firstly, there's nothing in the bill which requires the governments to come together to try and agree standards, to try and agree how there might be a mechanism for variation, and we have them already at the moment. So there's nothing in the bill which provides any space for that to happen, really. You've probably heard about the Common Frameworks programme, which is the kind of four governments negotiating standards and mechanisms in areas which are currently devolved to reflect the sort of arrangements we have as members of the European Union. And really our principle is that should continue to be the main way in which the four governments come together to deal with these issues. Now, once you've got a set of mechanisms through the common frameworks, and by the way, they were originally intended by the UK government to cover all those areas which affect the internal market. So that was the original proposal. So once you've got a mechanism through those frameworks, you can then accept a mutual recognition principle, because obviously any market requires that. But you're doing that on a basis which has been agreed, basically. Our view is that should be at the heart of the legislation in a way that it isn't now. And then the next thing is there are some parts of the bill which actually, reverse the devolution settlement. So one part of the bill actually extends the number of things in the Government of Wales Act which are reserved to Westminster. It adds to the things which are beyond the reach of the Senedd. So we don't think that's at all acceptable. So we need those things reversed, taken out of the bill, and state aid is the obvious example there. There's a whole set of issues around the UK government seeking powers to spend in devolved areas. We've seen today, haven't we, concerns that people have about the UK government not stepping up to its existing commitments to fund flood defence work in Wales, promises it's already made. So our view as a government is UK government, if it has additional funds to spend in Wales, should either provide them to us as a government in accordance with the existing devolution settlement, or spend it on things which they're currently underfunding, which they're responsible for. We're all really familiar with the issue around the breach of international law. So there's absolutely no way the government will recommend to the Senedd anything which involves a piece of legislation which is obviously unlawful. It's evident that bit of the bill is completely unlawful. And so whilst that is in the bill, there's no prospect of that being acceptable, obviously. And I suppose the last major issue is, and this is a little kind of technical and nerdy really, but the UK government is designating this bill as what's called a protected enactment, which would basically means that under the devolution settlement that the Senedd isn't able to legislate in that area, even when it deals with devolved matters. Now, that gives us a clue, really, actually, about what's intended here, because that is normally only suggested in relation to significant constitutional legislation. And it's very, very rare that it applies to the whole bill. So, I think that gives you a clue as to what's going on here, really. So all of those things would need to be changed. Actually, we are bringing forward amendments, which we hope then can be taken forward, in the House of Lords to deal with all those issues, really. And we are hopeful. We'll obviously be prepared to work with politicians of any party and none in Parliament to get as many of those things changed as we possibly can.
The amendments that you've proposed, do they fundamentally flip some of the way that the bill works on its head in order to kind of reverse some of those checks and balances so that they are more even across the United Kingdom governments? Or are they trying to modify the existing model that the bill seeks to follow in its current form?
That's a really good question. I mean, the bill currently has just the first thing I should say is we actually don't, this legislation isn't necessary, but we do think that some aspects of the internal market need legislation. We've always said that. In fact, that's part of the Common Frameworks programme. All the governments have accepted that. So I suppose what our approach and our amendments do is, as you say, to reverse the order of the process. So rather than start with the sort of nuclear option, if you like, of a mutual recognition principle, which actually provides a disincentive, really, for the UK government to continue talking to us about common frameworks. Why would you bother devoting energy to that if you had the nuclear option in your back pocket of being able to impose standards in your own part of the UK on all the other parts of the UK? It just doesn't make any sense. So we would reverse that effectively and say a mutual recognition principle is the end of the process, whereby you've gone through the common framework, you've tried to agree things, you've had, if there's a dispute between the governments, it's mediated, there's a mechanism for that to be resolved, and it's at the end of that process that you then apply the mutual recognition principle, not the start. So as you say, Richard, it sort of reverses, it flips it, if you like.
The Welsh Government has had some success in persuading different UK governments to change course on the way that their legislation is moving, thinking of the 2015, then 2016 Wales Bill, and of course some significant aspects of the withdrawal bill, which created the common frameworks process that you're talking about there. As things stand, and particularly given the timeline that we're working, which is more compressed and perhaps has less flexibility in it than any of those previous examples, how confident are you, given frankly the numbers at Westminster, particularly in the House of Commons, but also the kind of reception to this bill across all of the benches in the Commons, and the kind of mixture of reactions that have come from the Lords, because almost all of those have focused on the international law precedent, not necessarily much the internal future of the UK?
Well, I mean, it is true to say, as you say, that the focus given to the international law aspect and the breach of international law and indeed domestic law, by the way, in the bill has been the principal source of focus in Parliament. But I was struck, for example, that Theresa May, herself made a contribution which acknowledged the fact that this was damaging to the devolution settlement as well as the international relations that we need. So I absolutely think there's an understanding in Parliament across the parties that there are several challenges in this bill which need to be obviously addressed, and we would say, overhauled effectively. What's my confidence level about succeeding? Well, as you say, there's a government in Westminster which has a significant majority in the Commons. The preparation of this bill was not done on a collaborative basis. So, these are discussions which ought to have been happening as the UK government was developing a set of proposals, so that they could have been addressed along the way, if you like. So I take that point for sure, that the time is not, the time at the very least is not on our side. But I fear there are parts of the bill that the UK government will be extremely, reluctant to move on. I should say that our position as a government is always actually to do our utmost to be able to put forward, constructive alternatives and to press the case and to test and press the argument that's being put by the UK government, because that's our role as a government that would like to have a well and a better functioning union. I have this week had a short discussion, must be said, with UK government ministers where I've outlined, in detail really, what are our specific concerns to the bill, about the bill, and have, pressed them to bring forward alternative proposals really. So as with all these things, some of those discussions are, more difficult than others. And probably at this point, there isn't much benefit in me going into anything specific because it's a very early stage really. But I hope that some of the things we put forward will be taken on board, obviously. We, on Friday, have put forward a legislative consent memorandum to the Senedd, which encourages the Senedd not to give its consent, obviously. I'm confident myself, my own view is that unless the things that we've asked to be addressed are addressed, there is no prospect of the Senedd giving its consent to the bill. Obviously, we are then in the territory of what happens next, needless to say. We obviously know as well the Scottish Parliament is obviously very unlikely to give its consent. The Sewell Convention, as we all know, would tell us that the UK government wouldn't legislate normally without our consent in the Senedd. The last time we withheld our consent, the UK government, the only time in fact this has happened, the UK government proceeded notwithstanding that, which was obviously not very long ago. At that point in time, Michael Gove, Stephen Barclay and others said to us in terms really, these are unique circumstances, they're extraordinary, they're exceptional, and so it's in that context that we're proceeding despite the absence of consent from the Senedd. I think myself that in those circumstances and given the scale of the issue with this bill, the UK government would struggle to justify being able to proceed without the consent of the devolved government. Certainly it shouldn't do that.
We're talking about Sewell a bit more. It's only a convention and it's very hard it's impossible to enforce in the courts. What is available to the Welsh Government to sort of push back against this act or this bill if it became an act, given that its legal routes out of it are greatly limited if non-existent?
Well, as you say, Matthew, once primary legislation is difficult to challenge as it goes through Parliament, perhaps not entirely impossible, but difficult certainly to challenge. And obviously, as you say, the existence of the Sewell Convention, which says that the UK Parliament will not normally legislate, obviously allows the possibility for the UK Parliament to legislate, obviously, in devolved areas. That's, in my view, a weakness in the devolution settlement. I think it should say that the UK Parliament would never legislate in those areas, but there's obviously a debate around that. The practical point then is what happens, what's our response in Wales and Scotland and elsewhere? Well, there are already discussions going on about whether there's scope for testing some of that in terms of litigation and so on. As I say, in terms of primary legislation, that's usually very difficult. But the bill obviously depends a lot on making regulations. And obviously secondary legislation is much more capable of being challenged by judicial review. And a lot of the bill is implemented in that way. So, it's too early to say at this point because the bill is still going through Parliament, isn't it? But that provides a mechanism by which some of the considerations which ought to be taken into account now might be addressed later on, if you like. But the other broader political point actually is that if the UK government proceeds in the absence of consent, if the UK Parliament proceeds in the absence of consent in this situation, it will just illustrate, I think, how fundamental reform is needed of Sewell, really, because I think the range of concerns about this bill are so extensive that I think it will be absolutely obvious at that point that Sewell needs fundamental reform.
You talk about reforming Sewell, but obviously in the Welsh Government document, Reforming Our Union, we've talked a lot about reforming the Constitution in its entirety. Re-envisaging the way that sovereignty works in the UK is a big thing, making it such that each constituent nation of the UK is more sovereign than it has been. Do you think that this bill makes the case stronger than most other things have done for that reform?
In many ways it does. My view is very clearly that sovereignty derives from the people rather than from Parliament. So, there's in my mind, no political question around that. That debate is, in my mind, settled, but the Constitution doesn't reflect that exactly, unfortunately. But, even if you were to take the parts of the bill that are straightforward, the spending powers in devolved areas, the addition of things to the reserved list for devolution purposes, those go against the expressed wishes of people in Wales for those matters to be dealt with by the government and the Welsh Senedd. And I think so there are kind of head-on conflict in those areas. And I think it just illustrates the point that, the Constitution needs clear reform. I want to be really clear, this isn't this is a constitutional argument, but the reason it's important is because it feeds through very directly to the lived experience of people in Wales. It's not an academic, abstract discussion about where powers lie and what referenda mean. It's a very practical set of considerations around, standards in animal welfare, standards in the environment, standards in food safety, things that people in Wales rightly care a lot about. So there's a clear read across in that way. But we have said as a government that there needs to be a set of arrangements which allows parity of esteem between the four governments, and nothing could be further from that principle than the way this bill was developed. And also that there's a mechanism by which intergovernmental relations are put on a much more stable footing. So, what we have now is the nature and the appetite of the UK government for engaging with the devolved governments is a very significant part of the reality of intergovernmental relations. So you've probably heard us say previously that even under Theresa May, actually, relations in terms of engagement and participation in joint decision making and so on was better than it is under the Johnson government. Now, you can't proceed on the basis of those kind of preferences, if you like, in the 21st century in a significant, established democracy. That isn't the way in which you can proceed. And you need a set of arrangements and mechanisms which can survive, changes in government, can survive changes in personnel, and can survive people's, political preference, basically. They should be capable of, weathering the storm, depending, regardless of what's thrown at them, if you like. And we're very far from that sort of set of arrangements at the moment. And I think you can see a practical example of that in the things the First Minister's been talking about as a result of COVID. He's spoken about the need for a regular, reliable rhythm of engagement. And I think when it comes to something like a public health crisis of that scale, that becomes even more important, doesn't it? Because it's there's very practical consequences.
Can I just press you a little bit on that, on something you said earlier, tying into what you just said about UK government ability to reach into devolved areas as a result of this bill? One of the less clear arguments in the public sphere has been that the UK government is saying that this bill empowers the devolved administrations, and you've said very clearly in your evidence to the Senedd and also elsewhere that your view is that it disempowers to a certain degree the Senedd as well, and obviously Stormont and Holyrood as well. And you've given some very specific examples. So could you clarify this from the Welsh Government's understanding of the law, of the draft bill as it is? Does this bill give more or less power to the Senedd and more or less power for Westminster to act in Wales in a way that affects Wales?
Well, there's no question at all in my mind that this bill reduces the ability of Welsh ministers and the Senedd to operate the current range of devolved powers that each of those institutions have. I've asked to be pointed to the section to the clause in the bill which people say extends the powers of the Senedd. I'm still waiting for an answer. I think the argument runs, we're leaving the European Union, therefore, this is the bill that deals with the powers that come back from the European Union. Well, the reason that the powers of the Senedd and Welsh ministers are to some extent enhanced because after leaving the European Union, and by the way, that isn't a situation that we obviously have advocated, just to remind you of that, but the reason that they are enhanced to the extent that they are is by virtue of the devolution settlement. It's not by virtue of this bill. There's a worldview, I think, which is these powers come to Westminster and then they're handed out by Westminster. Well, that isn't how devolution works, and it isn't how the legislation which we already have works. The competences in Wales are kind of expanded by virtue of the existing settlement. So there's nothing in this bill which confers those powers on Wales or any other part of the UK. All it does is constrain the way in which powers, by the way, including pre-existing powers, not simply new powers, are exercised.
So on the example of state aid, for example, if this bill did not exist and was never passed into an act, state aid powers that have been held up to this point by the European Union, would they come to Wales? Would they come to the Senedd?
Well, this is a very kind of constitutional niche area, really. Our view as a government has been these are devolved. The UK government has never accepted that. The way the devolution settlement works is unless there's an express reservation in the Act, then it's devolved. That's the settlement that we have. We are confident that our analysis is correct, because if it was not correct, the UK government wouldn't feel the need to amend the settlement. So I think that tells you everything you need to know, actually. I think state aid is a very good and frustrating example, really, because actually our view as a government is that we need a UK-wide state aid regime. It doesn't make sense for each part of UK to have its own state aid regime. So, that's what we think is the right outcome. But fundamentally, the wrong way of going about that is to preserve those powers freshly, if you like, to Westminster. They should be where they already are, which is devolved in our view, and then those arrangements can be negotiated on a four-nations basis. That's the right way to do it.
This particular UK government seems quite happy to pick fights with people with whom it either disagrees with substantively or just doesn't like. And we've seen this with sectors of different economies. We've seen this with the European Union very clearly. They've not been shy at all about indicating their unwillingness to play by the accepted rules. And that seems to apply to a certain degree with the devolved governments as well, and devolved parliaments. How do you then go forward and try and be constructive? Because the Welsh Government is the one government outside of England which has tried to be actively constructive or the most actively constructive, trying to fix these things. How can you work in good faith with a government that has shown repeatedly that it is not so inclined to working necessarily in good faith with other sectors or governments?
Well, I mean, I try not to speculate about motivation, because I just don't. It's just hard to know, isn't it, really? But what I can tell you is the effect, certainly. So, just the first thing to say is, this bill represents a new low, but it's a very uneven picture. So there are examples of much better joint working between the government. So, for example, in relation to the international trade negotiations, which don't involve the EU, so third country negotiations, I think if you were speaking to Lynette Morgan about that, she would say to you, actually, there have been a number of very good examples where joint working in that space has been pretty positive, actually, to be fair. So that is obviously a thing that we welcome. Latterly, certainly, in relation to preparing for the end of the transition period, there has been an improvement in engagement. I would say it's from a lower start than we would have wanted, and later point in time than we should have had. But it has got better. And the truth is, actually, last year, when we were preparing for leaving the European Union without any sort of deal, by the end of that, I would say there was a good way of working, actually, on most areas, in terms of the preparation. That's the operational, delivery aspect, isn't it? It's when you come to the questions of policy where there's a difference of opinion between the government. So, a very good example of that would be the EU exit negotiations, for example. In that space, despite the efforts that we have put in as a government to take any opportunity, frankly, to make the case, we have not had the voice that I think people in Wales would have expected us to have. And yet, at the same time, there's a set of discussions going on to recast intergovernmental relations, the Intergovernmental Relations Review, which you might have heard mention. And actually, there's some progress in some of those areas. Now, they haven't been signed off and they haven't been approved officially, so I don't want to overplay that, because there's many a step betwixt cup and lip, as they say. But there are signs of progress, if I can put it like that. And so that's why but continuing to make progress under the shadow of the internal market bill is obviously a challenge for obvious reasons. But it's an uneven picture, and I think what that tells you is, it makes the point I was making earlier, really. It shouldn't depend on which portfolio ministers are more, have a better relationship, or which areas of government have a longer standing set of relationships. It shouldn't depend on any of that. These should be defensible, robust arrangements which exist through the political cycles, if you like.
Given there is a strong likelihood that this bill will pass into an act on a very quick timeline and ahead of those May elections next year, should they go ahead on their current timeline, is there a risk that if the UK government wished to use some of the new powers that would be given it through this act that actually that might have an influence on those elections next year?
Well, they would have done something to the devolution settlement that previous governments haven't done, which is either to reverse parts of it or circumvent parts of it. So I think voters in Wales who are interested in continuing to have governments in Wales exercising devolved powers will look at a Conservative government doing that and should form the clear view, that's obvious as a result of that about which parties are committed to devolution in Wales and which are not. It may have that consequence. But I think what will be clear if that bill becomes an act is that the case that we've made as a government for significant reform of the UK's constitution, actually, but in particular as it relates to Wales from our point of view, will have become that much more powerful, I think.
One more question before you go, Jeremy. If this bill becomes an act and becomes law, what do you think the State of the Union will be like after the elections in May next year?
Look, I think one of the strongest interventions in this space has been that from David Melding, actually, because he speaks as a Conservative about the actions of a Conservative government. And I don't want to mix things up for him, as it were, to muddy the waters. But the truth is, he is right when he says that a unionist government in Westminster, which cared genuinely about the the good functioning of the union into the future, wouldn't proceed on the basis that this one has. As a government, we want the union to work and to work better than it is working. There's certainly plenty of scope for that to improve. I do fear, though, that if we end up with a UK government which is seeking to exercise spending powers in devolved areas that people in Wales have elected a government to do, and a fresh government will be constituted in the new Senedd term. We don't know what that'll be, but there'll be a new government with a mandate, and it'll have mandate in education and in health and in housing. All of those areas are areas where the UK government is seeking direct powers to finance. So I think, that is why we are so concerned, really. And it is an unnecessary, it's an unnecessary step for the UK government to take. We've put forward, because we want the union to work and to function better than it does, we've put forward what we think are a set of, very workable, constructive alternatives, which, frankly, respect the devolution boundaries and deliver the same outcomes of a well-functioning market across the UK. I hope the UK government decide at some point that they need to engage with that.
Jeremy Miles, thank you very much for coming on.
Thank you.
If you like what you heard tonight, please don't forget to find us on Medium at HiraethBlogCymru, on Facebook at HiraethBlogCymru, and on Twitter at HiraethBlog.
Thank you for listening to Hiraeth. If you like what you heard, please don't forget to subscribe, rate and review.